The subcommittee will now come to order, and without objection, the chair is authorized to declare recesses of the subcommittee at any time. Welcome to this morning's hearing on the importance of a diverse federal judiciary. Before we begin, I would like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, and other written materials that members might want to offer as part of our hearing today. And if you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would like to ask all members to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself at any time you seek recognition. I will now recognize myself for an opening statement. Today, the subcommittee continues its discussion on an issue that impacts all Americans: diversity within the federal judiciary. This past March, in our first hearing on this topic, we discussed why judicial diversity is important. Witnesses explained how judicial diversity, both personal and professional, is essential to preserving public confidence and trust in our judicial system, protecting the rule of law, enhancing the quality of judicial decision-making, and making sure that exceptional lawyers who aspire for public service know that this path is open to all. Today's hearing considers how we can achieve those goals by examining a critical but often unexamined part of the pathway to becoming a judge, namely how a highly qualified lawyer's name gets into the pool of candidates from whom the president will ultimately select a nominee. As we will hear today, the process has varied widely across the country and over time, often dependent on the involvement of the home state senators where the judicial vacancy has opened, in addition to the president. I hope to learn more today about how we can ensure that highly qualified lawyers with a wide range of backgrounds and legal experience are able to participate in the judicial selection process. There has been progress on this front. Just 7 months ago, into his first year in office, President Biden has nominated a historic, diverse slate of experienced lawyers representing a broad array of professional legal backgrounds, including work as public defenders, prosecutors, labor lawyers, civil rights lawyers, Indian law practitioners, immigration lawyers, commercial litigators, clerks, academics, and state and federal judges. Their personal backgrounds are just as varied, from a retired Army captain who deployed twice to Iraq, who also happens to be the first Muslim ever appointed to a federal judgeship, to a state court judge who left his complex litigation practice to open his own practice specializing in immigration law in order to serve the community he grew up in. And yet, there is much more work to be done. One only need look at the current composition of our courts to see that for highly qualified lawyers who don't fit a certain profile, the path to the federal bench can seem as narrow as a tightrope. Female and minority judges are still sorely underrepresented on our federal bench, which is dominated by former prosecutors and corporate law firm partners from the most expensive law schools in the country. The lack of diversity is especially stark among bankruptcy and magistrate judges, who together handle the vast majority of the federal docket. The upshot is this: if you are a plaintiff or criminal defendant, you could very well look at the federal judiciary, taken as a whole, and wonder if you will get a fair shot. If you are a litigator or criminal law practitioner, you might wonder how you will be heard. And if you are an extraordinary lawyer who might want to be a federal judge, you might wonder if you really belong. These problems can seem daunting, but a growing body of best practices from state and federal judicial selection processes suggests that there are some straightforward steps we can take in the right direction. The witnesses for today's hearing bring with them unique knowledge and experience regarding the less visible but still critical parts of our judicial selection process. I look forward to hearing from them today as we move forward with this discussion and how best to address this important issue. And it is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from California, Mr. Issa, for his opening statement. Mr. Issa. And I do not see Mr. Issa on camera, so I will now move to the chairman of the full committee, the gentleman from New York, Chairman Nadler, for your statement.
Thank you, Mr. Chairman. Thank you for holding this series of hearings on the importance of a diverse federal judiciary. I appreciate the opportunity to focus today on the selection and confirmation process. A diverse federal judiciary preserves public trust in the courts and enriches judicial decision-making. But as I said at the subcommittee's first hearing on this topic, we need to determine why in 2021, our federal courts remain so strikingly non-diverse in so many ways, and what we can do to ensure that the path to the federal bench is open to all highly qualified lawyers willing to commit themselves to equal justice under the law. To be sure, we have made progress. Although the judiciary remains disproportionately white and male, and corporate law partners, prosecutors, and those with Ivy League degrees still predominate, the federal courts are certainly less homogeneous than they once were. But that progress did not just happen. It was the product of decades of effort by people like our distinguished witnesses and by political leaders who recognized the value of increasing diversity on the federal bench. This progress has unfortunately come in waves. It began in earnest under President Jimmy Carter, who created the Circuit Court Nominating Commission that was instructed to recommend lawyers who had demonstrated outstanding legal ability and commitment to equal justice under law, and whose training, experience, or expertise would help to meet a perceived need of the court. By the end of a single term, President Carter had appointed 4 times as many women to the federal bench as all of his predecessors combined, and more than twice as many people of color. Progress continued with President Clinton, whose White House counsel explained that they wanted nominees who were, quote, balanced people who had a life and a wide range of experiences, unquote. It resumed again under President Obama, whose White House counsel explained that, quote, the president wants the federal courts to look like America. He wants the people who are coming to court to feel like it's their court as well, unquote. The effort to ensure that our judiciary encompasses a wide range of personal and professional backgrounds has resumed once more under the Biden administration, whose White House counsel made clear in a letter sent to senators earlier this year that the administration wanted judicial nominees who, quote, represent the best of America, quote, who look like America, and, quote, who have a wide range of life and professional experiences. While presidents may set the tone for who they will ultimately nominate for a judicial vacancy, the judicial selection process in practice is far more complex than the requirements set forth in the Constitution that the president nominates and the Senate confirms. For example, most people may not realize that home state senators also often play a significant role in recommending district court nominees to the White House. And most people may not be aware that our bankruptcy and magistrate judges, who are even less diverse than the rest of the federal judiciary, are chosen by district and circuit court judges. But as I think our witnesses will explain, there are aspects of the process that resemble many other jobs. For example, people will not apply for a job unless they know about a vacancy and how to apply for it. And they probably will not apply if they do not think that they are wanted, or if they do not have an adequate system of support and resources to help them through what can be a long and complex process. That is true for potential judges. It is as true for potential judges as for anyone else. The late Justice Ruth Bader Ginsburg, for example, explained that, quote, "The first time I ever thought of being a judge was when Jimmy Carter announced to the world that he wanted to change the complexion of the US judiciary," which he did. Justice Ginsburg's story parallels the experience of many judges who have different personal and professional backgrounds than their colleagues on the bench. Fortunately, years of experience at both the state and federal level have given us some useful tools to make sure that highly qualified potential judicial nominees are not overlooked. I am pleased that we will be hearing from our distinguished witnesses about how to design a selection process that ensures that highly qualified lawyers know about a vacancy and how to apply, are encouraged to apply, and are evaluated fairly. I look forward to hearing from our witnesses on this very important topic, and I yield back the balance of my time.
Thank you. And we have now been joined by my colleague from California, the ranking member of the subcommittee, Mr. Issa, who has been having some persistent technological difficulties, and he finally is on. So thank you, sir, and the floor is yours for 5 minutes.
Thank you, Mr. Chairman, and I apologize for the poor video. I went to all the trouble of having everything set up perfectly, and the computer doesn't work, but the iPhone does. I want to thank you for holding this important hearing. As our committee considers the expansion of the court, more than ever, the question of getting it right with an additional perhaps 50 or more nominees, in addition to the 100 current vacancies based on retirements or senior status, I can't think of a more appropriate time to hold this hearing. There's no question at all that diversity within the court, or if you will, the court representing a diverse group that reflects the look of America, helps Americans believe that every American has access to the opportunities and that justice knows no particular color. There's no question at all that today the court does not reflect exactly America. First of all, the Supreme Court reflects Harvard more than it reflects other universities. It reflects more men than women, and it reflects, if you will, the legacy of its presidents who appointed those individuals, meaning it has currently more people appointed by Republicans than Democrats. That is not just true today, but it was true at the time of our founding. When George Washington appointed every member of the court and the replacements, he appointed more Supreme Court justices at a time when the Supreme Court was the court than any other president since. No question at all. He was a white male who appointed all white males. The fact is, today the court is diverse. Today the court includes Native Americans, Hispanics, women, men, people who were foreign born and people that were born here. But just as then, the court will never exactly reflect the population in the United States, but rather it will reflect the population of qualified candidates. One of the considerations that we will hear today is, in fact, are there sufficient qualified candidates? Are we getting the best and the brightest, no matter where they came from, to choose law, to choose judgeship, and to choose to serve for, quite frankly, less money and in some cases a harder job than they would choose if they remained in the other parts of their profession, including law. One of the things that will be confrontational at times will be, do we choose to have people represented, us in the court, because diversity creates people with different opinions? Or is diversity simply the legitimate statement by the court that everyone's there? If I stand or sit before an African-American judge or a woman, am I going to get a different case than if I sit before an Italian-American? One would hope, and I certainly believe, that if we pick the right judges, it will make no difference as to the country of origin, gender, or nationality of the judge. Many people today reflect the court, the high court, and say that it has a bias toward one side or the other because of who appointed them. That kind of discussion, although interesting and perhaps sometimes reflective of the types of people that and their opinions, also undermines the belief that the court, in the case of a single judge trying you for either criminal or civil, will in fact implement the law rather than their opinion or their bias. Today, we will have a discussion about, among other things, opinions and biases and whether or not the correct choice of judges give us a judge who is, he or she is relatively free of those biases that the rest of us enjoy in our private lives, but a federal judge cannot and should not and cannot enjoy in theirs. And Mr. Chairman, again, I thank you. I believe this is an incredibly important discussion and will lead to a better understanding by all of us of what we must do in the way of pushing for reforms in the court. And with that, I yield back.
Thank you, Mr. Issa, and I will now introduce our witnesses for the first panel. The Honorable Monica M. Marquez was appointed to the Colorado Supreme Court in 2010. She's the first Latina to serve on the court in its history. Among her many current commitments besides judging, she serves as chair of the Colorado Supreme Court's Task Force on Lawyer Well-Being and is a co-leader on the Bench Dream Team, a group of judges dedicated to diversity and inclusion in Colorado's judicial system. Prior to her appointment, Justice Marquez served as Deputy Attorney General at the Colorado Attorney General's Office and as Assistant Solicitor General and as Assistant Attorney General. Before that, she practiced general commercial litigation and employment law at a Denver law firm. Justice Marquez earned her bachelor's degree from Stanford University and her law degree from Yale Law School. She clerked for Judge Michael A. Panzer of the United States District Court for the District of Massachusetts and for Judge David M. Ebel of the United States Court of Appeals for the 10th Circuit. Welcome, Justice Marquez. The Honorable Ann K. McCaig joined the Minnesota Supreme Court in September of 2016, making her the first female Native American to sit on any state Supreme Court in the United States. A descendant of the White Earth Nation, Justice McCaig is a native of Federal Dam, Minnesota, where she grew up on the Leech Lake Reservation. She served as an assistant county attorney for 16 years in Hennepin County, Minnesota, handling child protective cases and adoption matters with a specialty in cases that fall under the provisions of the Indian Child Welfare Act. She then served as a district court judge in Hennepin County. Justice McCaig co-authored law school curriculum entitled Child Abuse and the Law and teaches as an adjunct professor. Among her many community engagements, she is a member of the Speakers Bureau for the Zero Abuse Project and a member of the State Tribal Court Forum. She attended St. Catherine University for her undergraduate degree and received her law degree from Hamline University. Welcome, Judge McCaig. I will next turn to my colleague, the gentleman from North Carolina, Mr. Bishop, to introduce Chief Judge Myers. Mr. Bishop.
Thank you, Mr. Chairman. I'm honored to introduce Richard E. Myers, the second Chief Judge of the United States District Court for the Eastern District of North Carolina. Judge Myers is a native of Jamaica, but grew up in Wilmington, North Carolina. He graduated summa cum laude from UNC Wilmington and with high honors and Order of the Coif from the UNC School of Law 8 years after yours truly. Judge Myers had a distinguished career as an attorney in private practice and as a federal prosecutor. He served as Assistant U.S. Attorney for both the Central District of California and the Eastern District of North Carolina and taught criminal law at our alma mater from 2004 to 19. In 2019, President Trump nominated Judge Myers to the district court bench and the Senate confirmed by an impressive 68-21 margin. Judge Myers became Chief Judge of the Eastern District of North Carolina this January. I was privileged to meet then Professor Myers during my tenure in the North Carolina Senate. I'm thrilled to renew the acquaintance and proud to introduce Your Honor to the committee today. I'm eager to hear your perspective in today's proceedings.
Thank you, and welcome, Chief Judge Myers. The Honorable Michael J. Mcshane is a United States District Judge for the District of Oregon. Prior to serving on the federal court, Judge Mcshane was a Multnomah County Judge for 15 years, presiding over a variety of criminal and civil cases. He was appointed to the county's death penalty panel in 2003 and handled over 25 capital cases. He teaches extensively on trial practice, advocacy, and evidence, and he focuses much of his time off the bench working with at-risk youth. Prior to becoming a judge, Judge Mcshane worked at the Metropolitan Public Defender's Office in Portland. Judge Mcshane grew up in rural Eastern Washington and obtained his bachelor's degree at Gonzaga University. Afterwards, he joined the Jesuit Volunteer Corps and worked with homeless parolees in Portland, Oregon. He then obtained his JD from Lewis and Clark Law School. Judge Mcshane is one of 11 LGBTQ active Article III judges and the first gay federal judge serving the District of Oregon. Welcome, Judge Mcshane. And before proceeding with testimony, I hereby remind the witnesses that all of your written and oral statements made to this subcommittee in connection with this hearing are subject to 18 U.S.C. Section 1001. Please note that your written statements will be entered into the record in its entirety, and accordingly, I ask that you summarize your testimony in 5 minutes. There is a timer that should be visible on your screen that should help you stay within that time limit. For this panel, we will not have any questions after the witnesses' testimonies. Judge Marquez, the floor is yours. You may begin.
Mr. Chairman, Ranking Member, and distinguished members of the subcommittee, thank you for this opportunity to address you today about Colorado's efforts to increase diversity of our state court bench. I will highlight just a few of our initiatives underway in Colorado, but my written statement includes several others, including links to more information about all of those programs. Our efforts to diversify our state court bench took on renewed intensity in late 2018, when, following a series of retirements, Colorado was left without a single Black district court judge serving in our state court system. This underrepresentation was emblematic of the lack of diversity throughout our state courts, and it prompted us to make diversifying the bench an urgent priority. Since that time, we have made some progress. Of our 300 plus state court judges, approximately 41% are now women. We now have 12 Black, 31 Hispanic or Latinx, 6 Asian American, 1 Native American, and 3 multiracial judges, reflecting increases in each of these categories since 2018. 3 key factors have contributed to our success. First, with bipartisan support, the Colorado General Assembly enacted legislation that established a full-time position responsible for education and outreach efforts regarding judicial vacancies and the application process. To our knowledge, Colorado is the first state in the nation to have a position of this kind within its judicial department. Sumi Lee, our head of judicial diversity outreach, has used a data-driven approach to identify outreach opportunities and develop robust educational programming. With her work, we aim to demystify the application and nomination process and make it more transparent and accessible to all potential applicants. Second, we've engaged the broader legal community in this effort. Our Diversity on the Bench Coalition includes affinity bar presidents, law school deans, judges, attorneys from private practice and government. This coalition partners with a number of community leaders and organizations to develop viable candidates for judicial vacancies, increase diversity on our nominating commissions, educate decision makers at all levels of our merit selection process about the value of a diverse bench, and promote the value of bench diversity through focused messaging, articles, and outreach to our broader community. Separately, our Bench Dream Team, a group of state court judges dedicated to diversity and inclusion, has partnered with the Center for Legal Inclusiveness to update an orientation video for our judicial nominating commissions. And this fall, the Bench Dream Team will pilot a new 6-month intensive coaching program to support diverse candidates for judicial vacancies. Our pipeline efforts extend to college and law students. Law School Yes We Can is one such program that mentors college students from underrepresented communities and prepares those students to apply for law school. This program offers networking opportunities, leadership training, and LSAT preparation. For our diverse law students, we provide a host of experiential learning and networking opportunities that can lead to clerkships through the Judge Lorenzo Marquez Appellate Externship Program, the Colorado Pledge to Diversity Summer Clerkship Program, and even in the pandemic, our new virtual coffee house called Java with Judges. Third, we promote the visibility of our diverse judges because we know it is difficult to be what you cannot see. In this vein, virtual meetings in the pandemic have actually boosted our engagement with judges and potential candidates from rural parts of Colorado. Through these many partnerships, we hope to light pathways to the bench from all 4 corners of our state. In closing, I can attest personally that having a diverse collection of backgrounds and life experiences among the judges on an appellate court leads to richer and fuller discussions of the issues and ultimately better and more thoughtful decisions. But equally importantly, having a diverse judiciary strengthens public perception that the justice rendered by our courts is truly equal. That perception of legitimacy is so critical. It promotes confidence in and respect for the decisions rendered by our courts, and thereby strengthens the rule of law itself. I thank this committee for its attention to these important issues.
Thank you, Judge Marquez. I'm sorry, thank you, Justice Marquez. Justice McCaig, you may now begin.
Bonjour, Mr. Chairman, Ranking Member, and members of the subcommittee. I am honored to have the opportunity to address you today on the important topic of diversity in the federal judiciary. My Indian name is Awanakwe. I am a proud descendant of the White Earth Nation and grateful daughter of the Leech Lake Reservation in rural Northwest Minnesota. In English, my name is Ann McCaig, and I am the first Indigenous woman ever to serve on any state Supreme Court in the history of this nation. In my native language, my tribal name means mist woman, which in our community is the blanket of mist in the morning that nurtures and protects the land across the White Earth Nation. I can speak from experience that we as Indigenous women are all mist women. We are protectors of our children, our spouses, and our communities. Yet history and life experience tells us that despite being protectors, we are far too often feel unprotected by systems that are supported and supposed to protect us, including the federal judiciary. Now, I could spend the remainder of my time rattling off the alarming statistics that illustrate why the federal judiciary contributes to our feelings and fears as Indigenous people, such as the fact that there have been only 4 Indigenous people who have ever served as federal judges since the founding of this republic. But I believe that my time is best served on focusing what I believe to be the critical reasons that greater diversity is needed in the federal judiciary, which is fairness and legitimacy. If you can imagine an Indigenous mother entering a federal courthouse and seeing a white probation officer, white staff for pretrial services, a white judge, a white prosecutor, a white public defender, a white court reporter, dictating her destiny moving forward, she begins to believe that this process is not legitimate or fair for her. She no longer feels a part of the self-governance that we so hold dear in this country. Diversity in the judiciary isn't simply about the color of a person. It goes to the very core of what we need to preserve, the role of the judiciary, belief that all of us, we can wield power in creating and maintaining our republic and feel a part of the system. I have a very non-traditional path to the bench, and one that would not have taken place but for the fact that I saw my mentor, Judge Robert Blazer, the first Native American judge appointed to the Twin Cities District Court, and I saw his investiture process. I did not know him. I went and stood in the back of the room, and it was during the course of his investiture that I began to believe that a young woman from a reservation, a hometown of 106 people, could potentially be a judge one day and serve her community as a whole. It was through his mentorship and belief in me and helping me see that I had a greater obligation to my community, that I could be a part of the solution. Now, Minnesota has made, I believe, great strides in diversifying our judiciary. We have held judicial boot camps, which have been specifically sought out to the affinity communities so that we can demystify the judicial selection process. We have set up strong mentor programs like the one that I experienced with Judge Robert Blazer. We have a strong judicial commission that includes members that are also from the public. We have done much public speaking, including outreach events such as the Minnesota Supreme Court going to the Red Lake Reservation, the first visit in our history to any Indigenous nation. We also travel to high schools and hold court hearings as though they were at our court in the high schools and spend time with students to encourage them, including all students, that they too could have a dream of becoming a judge. It is incredibly important that those who come before our court systems feel that they are a part of the system and that they have a real opportunity to be heard. I am grateful for this opportunity today. I thank you for all the work that you are doing. Miigwech.
Thank you, Justice McCaig. Next, we will hear from Chief Judge Myers. Chief Judge Myers, please, you may begin.
Thank you, Mr. Chairman, ranking member, distinguished members of the subcommittee. First, a fairly selected judiciary is crucial because of the messages it sends regarding equal opportunity, access to the courts, and the fairness of our judicial system. Discriminating on the basis of immutable characteristics damages and deprives those who choose to discriminate, and it damages those excluded or chosen for that reason. Absolute equality of opportunity is essential to judicial selection and to the public's faith in the judiciary. No American should believe that someone like me can't get fair consideration for any position of public service. Today, I want to talk a little bit about the path to a diverse judiciary and the collateral consequences of the choices we make along the way. First, a little bit about my own path, and then a look to the future. I'm a Jamaican immigrant of mixed ancestry. My family moved to Miami in the late 1970s. In the early 1980s, we moved again to Wilmington, North Carolina, where I now sit as a federal district judge. I may represent the future of the color line. There are people eager to place me into a racial category for reasons of their own, but my background and appearance defy simple categorization. When my family moved to Wilmington, I was repeatedly asked, "What are you?" This was intended to provide the asker with racial information to fit me for their pre-existing pigeonhole. 40 years ago, my opportunities and social status were very much dependent on the answer. The answer Jamaican was insufficiently specific for some and was often followed by the more pointed question, "No, what race?" My answer, the human race, was deemed by some people to be too clever by half, but it was and remains my answer. I embody the American motto, e pluribus unum, or the Jamaican equivalent, out of many, one people. This inquiry into my race has not gone away, although the consequences have changed. I remember friends of different races in law school arguing over my race, fortunately in an attempt to claim me rather than disclaim me. At every career stop, I was encouraged to select particular boxes on personnel forms to ensure that the organization hiring me got credit for diversity. All this was troubling to me because it fostered the perception that I would be treated as a representation of some category, not as a unique individual with my own talents, goals, and dreams. Fortunately, I felt none of this racial pressure when I was selected as a candidate to be a federal judge. At the time, I was a law professor at the University of North Carolina School of Law. I brought a specific kind of diversity there too. I was an outspoken advocate of textualism, originalism, and judicial restraint within the increasingly liberal legal academy. My exposure to thousands of law students and leaders in the legal field within our state as the conservative law professor, I'm sure was a significant reason I was nominated. Before joining the academy, I served as a federal prosecutor and as a defense attorney before that. The combination of personal autobiography and legal philosophy has caused whiplash for some people's preconceptions. I can happily say that at no time during my selection and nomination process was I asked about my race until after my confirmation hearing. Ironically, as I was walking out of the hearing, a reporter pointedly asked me what race I was and told me that the president was criticized by people who had never met me for failing to select a diverse candidate. Looking forward, racism is real. I have personal experience with it, but I also believe that justice is blind and that all justices and judges wear the same black robes for a reason. We need to strive self-consciously and mightily to achieve Martin Luther King's dream, to create the day when we all are judged not by the color of our skin, but by the content of our character. This is my chosen country. I've taken multiple oaths to uphold and defend the Constitution of the United States. At my naturalization ceremony, again when I became an assistant United States attorney, and yet again when I became a federal judge. We amended our Constitution multiple times to further commit us to the principle that all people are equal before the law. We still have much work to do before we fully accomplish that goal. As a judge, I strive every day to find neutral principles of law and apply them neutrally to all of the people who appear before me without fear or favor. If the public reasonably believes that a potential judge was excluded or chosen because of an immutable characteristic, then we as a nation lose faith that the judge chosen was truly the best choice amongst all of those available. I encourage our leaders to remain committed to the proposition that all people are equal before the law, to consider every potential candidate as an individual with all of the nuance that that requires, and to broaden the pipeline so that we can seek the best candidates without fear or favor. Again, thank you.
Thank you, Chief Judge Myers. Now we will turn to Judge Mcshane. Judge Mcshane, you may begin.
Greetings from Oregon. I want to thank the committee and its leadership for inviting me to speak today on this topic of diversity. I'm not going to speak today on the importance of diversity. I believe this body would not be holding such a hearing as this if it did not understand why a truly diverse federal bench is important to our democracy. Instead, I want to talk about some of the challenges we as a court are facing in our attempts at diversity and inclusion, and some of the steps we can make to widen the opportunities for a broader spectrum of judicial applicants. This means looking at the traditional pathways to the bench and exploring some of the non-traditional pathways to the federal bench. The last time I had an opportunity to speak on the subject of diversity was a few years ago before a group of clerks and young lawyers at the federal court administrative offices in Washington, D.C. It was part of a gay pride event celebrating Gay Pride Month. One of the young lawyers asked me, how can we diversify the federal courts? Without giving it much thought, I blurted out, well, we need to lose our addiction to Yale and Harvard. The entire room went silent. The fact is, almost every lawyer in the room had in fact gone to Yale or Harvard. I'll be the first to say that these are great law schools, but diversity and inclusion cannot rely simply on the pedigree of a diploma from a particular school. It requires us to reach out proactively and invite more people to the table. So why are the traditional pathways not working? What are the traditional pathways? Well, one of the first traditional pathways is judicial clerkships. Many of my colleagues, and if you look, most of the justices on the Supreme Court began their career as a judicial clerk. It's a job that opens doors. But when it comes to the hiring of clerks, local law schools and regional law schools are often overlooked in favor of the top-ranked schools. But it is in these schools that we find that they are much more accessible to a diverse group of students from rural communities, working moms and dads, students caring for an aging parent, students who were the first in their family to navigate higher education, minority students, and students who quite frankly had to hold real jobs to survive while they went to school. I've had clerks from top law schools and I've had clerks from local law schools. They are equal in their excellence. I think sometimes the only difference is the local law schools actually grade the students' work. Another traditional pathway to the federal bench is the magistrate judge positions. In most districts, magistrate judges are chosen by the Article 3 judges themselves. There is a tendency to pick somebody who is a known quantity, somebody we are familiar with, who we have seen in court. That often tends to be somebody who looks a lot like us. And that often is somebody from the U.S. Attorney's Office or a law firm. But we need to encourage people who don't necessarily look like us to apply. I was very proud that the District of Oregon 3 years ago selected the first Muslim American judicial officer in United States history when we selected Mustafa Kasabai to sit as our newest magistrate judge. I've sat on many panels where invariably at a law school we are asked, what is the path to becoming a federal judge? The traditional answer is to work at the U.S. Attorney's Office or a large reputable law firm. These are good answers, but why do we rely on these traditions if we are seeking true diversity? Why aren't we able to tell these young minds, go work with the poor, get a job with legal aid, be a public defender, become an immigration attorney, help injured workers, represent veterans in Portland or farmers in the Klamath Basin? I know that when I was nominated to the bench, it was very important to the Obama administration that I came from a public defender background. They seem to tout that just as quickly as they touted the fact that one of my friends actually added PD, public defender, to LGBTQ because it was so rare, and I still feel like I'm a little bit of a unicorn with that public defender past. But we need to explore these non-traditional career paths and at least ask the question, why are we not seeking out those who work with the poor and the marginalized? Is it they are less intellectual? Is it they cannot be fair? Serving the poor and marginalized should not be a strike against anyone who, if they have the detachment necessary to follow the law. I was a public defender and I opposed the death penalty. When I became a judge, I had to sentence somebody to death because it was the lawful verdict of the jury. I followed the law. That's what we do. Finally, we need to work closely with the diversity law associations and encourage their student members to apply for clerkships, their young attorneys to participate in federal court activities, and their qualified members to seek appointments. And the diversity law associations have to work together and not against each other. In my nomination process, the diversity bar associations came together and worked together and came up with a number of endorsed candidates that they could put forward to our senator. It was only because of that that my name was able to get through and eventually become nominated. So I'm so happy to see some of the diversity bar associations are represented on our second panel. So thank you for giving me this opportunity. I'm happy to, at any time, answer any questions.
Thank you, Judge Mcshane. And this will conclude the first panel testimony for today's hearing. And I'd like to thank the witnesses for their participation and for their testimony. We will now transition to the second panel of witnesses. And with those witnesses now being on our screen, I'll now introduce them. Mr. Ian Warner is the co-chair of the Judicial Merit Selection Committee for the Western District of Washington, which was established by Washington State's U.S. Senators Patty Murray and Maria Cantwell. In this role, he and the committee review candidates for the positions of U.S. District Court Judge, advise the senators on the committee's findings, and suggest potential candidates for federal court vacancies before the senators make their final recommendations to the president. Outside of his work with the Senators' Judicial Merit Selection Committee, Mr. Warner is the Senior Director for Public Policy with the Zillow Group. Prior to this role, he was legal counsel for the mayor's office for the city of Seattle and an associate with the law firm Dorsey and Whitney LLP, practicing in the areas of banking and finance, securities, employment, and construction law. Mr. Warner received his Bachelor of Arts degree from Whitman College and his JD from the University of Washington School of Law. Welcome, Mr. Warner. The Honorable A.B. Cruz III is the President of the Board of Governors for the National Asian Pacific American Bar Association. He also currently serves on the board of Graph Acquisition Corporation Incorporated and is a senior advisor at Barker Gilmore LLC, providing executive coaching and search services to legal leaders, CEOs, and corporate boards. He also has served and currently serves on many nonprofit and charitable boards. Admiral Cruz has helped lead several prominent companies to diverse industries. Admiral Cruz has helped lead several prominent companies in diverse industries, including USAA, Emergent Biosolutions Incorporated, and Scripps Network Interactive Incorporated in a variety of senior legal and executive roles. He is also a former Navy admiral who, during his 33+ years distinguished military career, led numerous high-performing operational teams and represented the United States internationally in multiple high-level engagements with foreign militaries. Over the course of his naval career, he served as Deputy Director of Maritime Operations for U.S. Fleet Forces Command and as Deputy Commander for both U.S. 4th Fleet and Naval Forces Southern Command, among other posts. Admiral Cruz holds a JD from the Catholic University of America, an MA in Marketing from the University of Maryland, and a BS in General Engineering and Physical Sciences from U.S. Naval Academy. Welcome, Admiral Cruz. Ms. Jennifer Berseras is the Director of the Independent Women's Forums Law Center, a nonprofit organization that focuses on women's policy issues. Prior to this role, she was a contributing columnist and analyst for various media and news outlets like Boston Globe Media, the Boston Herald, New England Cable News, and later became the editor-in-chief of the New Boston Post. Ms. Berseras served on the U.S. Commission on Civil Rights for approximately 6 years after having been appointed by President George W. Bush. Before serving on the commission, she was a research fellow at Harvard Law School and a legal fellow with the Independent Women's Forum. Ms. Berseras was also an attorney with the law firm Ropes and Gray LLP, where she practiced labor and employment law. Ms. Berseras earned her Bachelor of Arts from the University of Massachusetts Amherst and her JD from Harvard Law School. Welcome, Ms. Berseras. Ms. Elia Diaz-Yeager is the President of the Hispanic National Bar Association. She is a frequent speaker and CLE presenter and serves as a diversity facilitator for the Louisiana State Bar Association. Ms. Diaz-Yeager is also a shareholder in the insurance section, Luginbull, Wheaton, Peck, Rankin, and Hubbard, where her primary areas of practice include industrial employment, insurance defense and coverage, environmental law, commercial litigation, and board governance and cybersecurity. Ms. Diaz-Yeager also serves as the Secretary of the Board of Directors of On Path Federal Credit Union, whose mission is to strengthen the financial health of underserved communities through financial service and education. In addition, she has co-founded and volunteered in many other community organizations, such as the A.D. Crossman Esperanza Library Project. Ms. Diaz-Yeager received her Bachelor of Arts, Bachelor of Science, and her Master's in Science from the University of Southwestern Louisiana, and her JD from Loyola University, New Orleans College of Law. Welcome, Ms. Diaz-Yeager. Before proceeding with testimony, I hereby remind the witnesses that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to 18 U.S.C. Section 1001. Please note that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. There is a timer and it should be visible on your screen. That should help you stay within that time limit. Ms. Warner, you may begin.
Mr. Chairman, Ranking Member Issa, and members of the subcommittee.
And
I'm
please
honored-
excuse me, Mr. Warner, I'm sorry.
No worries, Mr. Chairman. I'll begin again. Mr. Chairman, Ranking Member Issa, members of the subcommittee. I'm honored to address you today. Similar to my written testimony, my comments today will primarily focus on the Judicial Merit Selection Committee for the Western District of Washington, which I co-chaired in 2020. But I will begin with a bit of context, including part 1 of this subcommittee's hearing on judicial diversity. In that March hearing, several esteemed judges and academics articulated the statistical realities that the federal bench has lagged behind the diversity of our country and of our legal community. They also definitely explained the importance of judicial diversity in terms of procedural justice and perception of trust. So with that information already established in this committee's record, I will add that the U.S. District Court for the Western District of Washington has never had a lifetime Native American or Asian American federal judge, considering that there are 29 federally recognized tribes in Washington state, and that Washington state is home to one of our country's largest AAPI communities. I will also note the recent Cato Institute study, which found that the ratio of prosecutors to defense attorneys on the federal bench today is almost exactly 4-to-1. So in the context of today's hearing, focused on the selection and confirmation process, what do these statistics mean? This lack of diversity on the bench speaks directly to potential judicial applicants to say, need not apply. If you are from underrepresented legal backgrounds, women, lawyers of color, LGBTQ, or Black. These statistics also speak directly to witnesses, litigants, and the community to say, you are an outsider here. These realities must be addressed because the range of interests and people that appear before the federal judiciary are broad. We must encourage qualified and historically marginalized potential candidates to apply by being clear that we believe Black, Brown, Native American, Asian American, women, and LGBTQ lawyers can also represent the best of our legal profession. And this year, we were able to say that the White House is serious about bringing in professionally diverse, historically underrepresented people to the bench. You should apply. The 2020 committee was intentional about meeting that call from the President and Senators Murray and Cantwell. Last December, we convened to nominate candidates for 5 judicial vacancies on the Western District bench, one of the highest overall sets of vacancies in the country. Importantly, Senator Murray made several changes to the committee's composition with the intent to increase the diversity of legal experience in the committee. The committee's appointments included a then U.S. attorney, a former longtime federal defender, an ACLU executive director, a youth legal aid attorney, and others. Our youngest member was 33. Black, Latino, Native American, and other racial and ethnic groups were represented. At the committee's first official hearing, we heard directly from Senator Murray's staff and discussed the December 22, 2020 letter from White House counsel designate Dana Remus. That letter highlighted the White House's interest in candidates with, quote, legal experiences that have been historically underrepresented on the federal bench, end quote. Meeting the directive to address historical underrepresentation required innovation in our approach. Innovation is often driven by diversity. In this context, the committee's diversity and innovative recruiting processes were essential to attracting diverse applicants reflective of our community. We knew that the committee members, with their deep community connection to the Seattle and Tacoma, Washington legal communities, made it generally more likely that professionally diverse and historically underrepresented applicants would apply. But that representational diversity was and is still not enough. We also encourage the membership to highlight the application process within their networks and directly to reach out to qualified applicants who might otherwise hesitate to apply. We also publicize the vacancy announcement through expanded channels, including the Western chapter of the Federal Bar Association, local minority bar associations, and local media outlets. The result of those recruiting efforts was the largest and most diverse applicant pool since the committee's inception. We received more than 75 applications that truly represented Washington's broader legal community. The committee then met over the course of approximately 8 weeks and deliberated until we reached consensus on a slate of nominees. The outcome was the most professionally diverse recommendations in the committee's history. Those candidates included civil rights attorneys, public defenders, a native law expert, and former U.S. attorneys. And now, in conclusion, this very week, the Senate Judiciary will vote on 3 of our outstanding nominees. Lauren King, a tribal member who would be Washington's first Native American federal judge and a tribal law expert. Tana Lynn, a civil rights attorney and former public defender who would be Washington State's first Asian American federal trial judge. And Judge David Estudillo, a current Superior Court judge in Grant County, a rural area of Washington State that is home to farming and agricultural communities. This cohort of outstanding nominees look like America and will play a key role into creating a Western District bench that reflects and engenders trust in its community. I want to thank the members of the subcommittee and their staff for holding this hearing on such an important topic and welcome your questions. Thank you.
Thank you, Mr. Warner. Next, we will turn to Admiral Cruz. Admiral Cruz, you may begin.
Good morning, and thank you, Chairman Johnson, Ranking Member Issa, and I see Committee Ranking Member Jordan, distinguished members of this subcommittee. It is indeed my honor and privilege to appear before you on behalf of the National Asian Pacific American Bar Association, or as we call it, NAPABA. Thank you for highlighting the importance of a diverse federal judiciary, which is so critical for ensuring faith and confidence in the rule of law. NAPABA represents the interests of over 60,000 Asian Pacific American, or API, lawyers and consists of a nationwide network of nearly 90 affiliates. NAPABA is a leader in addressing civil rights issues, confronting APA communities, and we have always been strong national voice for increased diversity on the bench, for equal opportunity in the workplace, and for combating hate crimes and discrimination. For the APA community, the hearing comes at a crucial moment. Throughout the country, we are confronting the twin scourges of anti-Asian American hate and COVID, for which so many Asian Americans have been falsely scapegoated. The APA legal community has responded to help a population that has suffered thousands of attacks, to represent victims, and to use all legal mechanisms available to attain justice. But in order for our justice system to work as our founders designed it, with independence and sacred constitutional duty to safeguard rights and liberties, the American public must be assured that it is fair, impartial, and will provide equal justice for all. For the APA legal community, representation on the federal bench continues to be a struggle. Out of 673 federal district court seats, only 27 are held by active APA jurists. Of 179 federal appellate court seats, only 10 active APA judges serve. As this subcommittee knows, there has never been an APA candidate even nominated to the Supreme Court. Underrepresentation is not confined to the federal bench. Currently, only 6 states have an APA justice sitting on their state Supreme Court. So what accounts for this disparity? The APA legal community faces particular barriers, including inadequate access to mentors, lack of role models, and lack of recognition. Stereotyping, even for ostensibly positive traits such as hard work and quiet diligence, has often disadvantaged APA attorneys who may be passed over for high-profile assignments because of misguided perceptions that they're too passive to be effective in a litigation or a courtroom setting. Within the APA legal community, there are identifiable gaps in the judicial pipeline. For example, APA law students are well represented in top-tier law schools, yet they do not obtain judicial clerkship in comparable numbers. APA lawyers are significantly underrepresented in law firm partnership ranks, and APA lawyers are underrepresented in public sector leadership. Traditional pathways to the bench, including clerkships and law firm partnerships, often involve highly subjective criteria such as likability, leadership potential, and other amorphous factors as to whom judges, professors, and partners regard as their protégés. If I may, I'd like to share a personal story about why representation really matters. When I was a midshipman at the Naval Academy, and even after receiving my commission, the lack of diversity in the officer corps really struck me. My career had been driven by an abiding love of this country. As the son of immigrants and a strong sense of duty and a deep pride in the Navy. But there were times during my career when I wondered, does this Navy reflect who I am as an American? Well, I can tell you that when I was assigned to my very first ship, I was one of only 2 officers aboard the USS Gray. One day, when I got a knock at the door, and when I opened it, in rushed a crowd of minority sailors of all different backgrounds. They told me how inspiring it was to see an officer of color aboard. And for once, for them, the Navy was not someone else's Navy. Faith and confidence in leadership was enhanced because these sailors saw themselves in me. That moment changed my perspective. It wasn't about me, it was about all those who aspired to be me. My written testimony discusses how, in a diverse nation, a broadly representative military with a diverse officer corps is more likely to uphold national values and be loyal to the country they serve. Put simply, diversity is not a buzzword. It is mission critical. It's an imperative. The saying goes for the legal profession. As a former naval officer, I recognize in a courtroom, the judge is the presiding officer. Look, judicial candidates will rise and fall on their own merits as it should be. However, we can and must do more to cast a wider and deeper net to attract a broader pool of highly qualified applicants, and those applicants must have role models, mentors, and networks to help them succeed. In order for the rule of law to endure and thrive in this country and to prevent a loss of faith and confidence in the judicial system, the courts cannot be someone else's, but rather must belong to all people. Thank you for the time, and I'm happy to answer any questions you may have.
Thank you, Admiral Cruz, and thank you for your military service to the nation. And next, we will proceed to Ms. Berseras. Ms. Berseras, you may begin. And if you will unmute.
There we go. Chairman Johnson, Ranking Member Issa, distinguished members of the committee, thank you for your invitation to testify. My name is Jennifer Berseras, and I am the Director of Independent Women's Law Center, a former commissioner on the U.S. Commission on Civil Rights, and a member of the Hispanic National Bar Association. A judiciary that reflects the vibrant tapestry of America enhances the legitimacy of our system and gives Americans confidence that justice is impartial and that our courts are accessible to all. It is undeniable that the historic appointments to the Supreme Court of Sonia Sotomayor, Sandra Day O'Connor, Antonin Scalia, Thurgood Marshall, and Louis Brandeis had special meaning for Americans from certain communities. Even at the lower court level, the confirmation of a judge from a particular background is often a source of great pride for the community. Politics, whether partisan or ethnic, will always influence judicial nominations to some degree. Our Constitution anticipates this by allowing politicians to pick judges of their choosing from constituencies of their choosing. But neither politics nor diversity should ever be the primary factor in selecting judges who serve for life. The primary factor in selecting a judge should not be race or ethnicity or sex, or even an elite educational pedigree, but rather judicial philosophy. The best judges are those who understand that their role is not to correct the world's ills, but to resolve specific disputes according to the law. Good judges act with humility and with restraint, tethering their rulings to the law's original meaning, not the political winds of the moment. From a qualified pool of nominees committed to originalism, restraint, and impartiality, politicians can, of course, consider diversity as a plus. So how are we doing with respect to judicial diversity? Statistics never tell the whole story, but consider these. According to the American Bar Association, in 2020, the legal profession was less than 5% African American, less than 5% Hispanic, and less than 3% Asian American. And yet the Washington Post reports that the federal judiciary is almost 13% African American, 9% Hispanic, and almost 5% Asian American. Given the makeup of the profession and the pool of possible candidates, our federal judiciary is in fact remarkably representative. And it would seem that the best way to increase diversity on the bench is to broaden the pipeline by expanding opportunities to attend law school in many of the ways that Justice Marquez mentioned in her testimony. Representation matters, but diversity is often a moving target, one that encompasses an ever-expanding list of subgroups, immigrant communities, genders, and religious and sexual minorities, not to mention various intersectional combinations. Statistical parity is, of course, not possible, and it should not be our aim. Unfortunately, one obstacle to a more diverse federal bench has been the hypocrisy rooted in racism that the only legitimate members of an ethnic or racial group are those who expound a particular dogma. I'm old enough to remember how in 2003, Democrats used the Senate filibuster to block the nomination to the DC Circuit of Miguel Estrada, one of the most brilliant lawyers in America and the epitome of the American dream. I have also been around long enough to observe the 30-year campaign by people who purport to care about diversity to delegitimize Justice Clarence Thomas as inauthentically Black. Sadly, as these examples make clear, those who claim to want a more diverse federal bench often do not. In conclusion, the goal of judicial selection is not proportional representation, but the creation and maintenance of the most fair and impartial judiciary in the world. As we seek to diversify the legal profession and in turn the federal bench, we must never forget that the most important qualifications for a judge are good judgment and commitment to the rule of law. Thank you for having me. I'm happy to answer any questions you may have.
Thank you, Ms. Berseras. Next, we will turn to Ms. Diaz-Yeager. Ms. Diaz-Yeager, you may begin.
Thank you, Chairman Johnson, Chairman Nadler, Ranking Member Issa and Ranking Member Jordan, and distinguished members of the subcommittee. Thank you for holding this critical hearing on the importance of judicial diversity. I am honored to be here. My name is Elia Diaz-Yeager, and I serve as president of the Hispanic National Bar Association, or HNBA. The HNBA is a nonprofit, nonpartisan national membership organization that represents the interest of more than 67,000 Hispanic legal professionals, as well as the nearly 13% of law students enrolled in ABA accredited law schools in the United States and its territories. We act as a collective voice for issues of common concern to our members and our community. Our organization has been working for over 50 years to support the recruitment, retention, and elevation of Hispanics in law schools, law firms, corporations, the judiciary, and government. The HNBA has worked vigorously to identify, vet, and endorse qualified individuals to fill the numerous vacancies in the federal court system. Since the start of the current administration, the HNBA has endorsed and provided the White House and U.S. senators with 48 qualified candidates for federal judicial vacancies, 47 of whom were Hispanic. Today, I will touch upon the importance of judicial diversity, challenges in the selection and confirmation process, and the path forward to increasing diversity in the judiciary. According to data from the Federal Judicial Center, only 9% of active federal judges identify as Hispanic, despite the fact that Hispanics are the nation's largest minority group, representing almost 20% of the U.S. population. Additionally, there are currently no Hispanic judges in 36 of 50 states. Research supports the value of diversity on the bench. A diverse bench provides for diversity of experience, perspectives, and backgrounds, and it creates a pipeline for future judges that reflect the communities they will serve. A diverse judiciary also helps combat implicit bias in our government institutions and instills public trust in our system of justice. Moreover, diverse backgrounds and experiences keep implicit bias in check. While identity does not predict viewpoint, studies point to the presence of diversity as improving outcomes, and we believe the same is true in the judiciary. Sadly, there are several challenges diverse candidates face when navigating the current selection and nomination process. Procedural and personal biases in the confirmation process limit opportunities for qualified Hispanics and other minorities seeking to serve on the federal bench. Another challenge is the decentralization of the nominations process. The selection process consists of 100 different U.S. senators making their own recommendations, each with differing views on the value of diversity. As a result, if judicial diversity is not a priority in the administration of power, the demographics of judicial nominees recommended by the senators will tend to reflect themselves and their networks. However, there are proactive measures that outside stakeholders can take to advocate for more diverse candidates. For example, the national affinity bars like the HNBA and a number of other interest groups that care about the composition of the judiciary can vet and put forward qualified candidates to both the White House and senators. Another challenge to diversity on the bench is bias faced by traditionally underrepresented individuals. A recent study by the ABA found that widespread gender and racial bias permeates hiring, promotion, assignments, and compensation in the legal industry. Similarly, statistics show that those same biases are prevalent in the selection of judicial nominees. Even in situations where there's no personal biases at play, key decision makers in the process often turn to their own narrow networks for judicial recommendations. As a result, the current judicial selection process naturally causes an unintentional bias that results in judicial nominees who are lacking in diversity. So what can be done to widen the path forward to increase judicial diversity? The administration's nominations to date are indeed a positive sign of movement toward a more diverse representation of federal judges, one that actually reflects the communities that come before our courts. That this progress is a strong example of how decision makers can exercise power they have to affect change. Change can also be affected by key decision makers opening their selection process to include stakeholders outside of their usual networks. Rather than relying on the same law schools or exclusive institutions and networks, a more inclusive process, one that incorporates a wider breadth of practice areas, law schools, experience, backgrounds, and expertise, will naturally lead to more diverse candidates being provided the opportunity to be considered. In turn, that will result in an increase in mentorship and pipeline growth. I want to thank the subcommittee for taking time to consider this critical issue. Public dialogue around the lack of diversity in the judicial system helps raise awareness both about the need and the challenges in promoting diversity on the bench. On behalf of the HNBA, we welcome further dialogue with the members of this subcommittee and working to promote diverse candidates onto the federal bench. Thank you, Chairman Johnson and Ranking Member Issa, for holding this hearing today and for inviting our organization to speak. I look forward to answering any questions you may have.
Thank you, Ms. Diaz-Yeager. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Admiral Cruz and Ms. Diaz-Yeager, I'd like to discuss why judicial diversity matters. At the subcommittee's first hearing on this topic a few months ago, Judge Edward Chin explained, recounted a number of instances where a judge drew on their own life experiences with their colleagues to help their colleagues to understand crucial elements of a case in ways that they might have missed. For example, Judge Chin described how Justice Ginsburg helped her colleagues see how a strip search might feel to a middle school age girl, and how Judge Henderson, the first Black judge on Judge Chin's court, explained to a colleague that the shockingly racist graffiti a plaintiff described was far more common than his colleague thought. Judge Chin explained that, quote, there is a cost when voices are missing from the room, end quote. Do you agree with that sentiment? First, Admiral Cruz, and then Ms. Diaz-Yeager.
Yes, Chairman, thank you for that question. I do believe that it is imperative that there be diversity of views, perspectives, and experiences. It's not only a good thing, it is an imperative. The more voices you have at the table, the more perspectives, the more robust the discussion and debate and the challenges are. What this results in is more beyond the norm thinking, greater creativity, greater innovation, and ultimately, my belief and my experience says better decisions and better results. So again, that is why any organization, whether it be a corporation, whether it be the judiciary, diversity of views and perspectives, experiences is an imperative.
Thank you, Admiral Cruz. Ms. Diaz-Yeager.
Thank you. I would echo what A.B. Cruz has just said. It's imperative that a broad perspective and a broad understanding and ability to get that information from others helps you understand and put things into perspective. And the more background, the more experiences, the more different types of individuals that are on the bench that can work together actually helps you get a better perspective and indeed a better outcome and a better result.
Thank you. Mr. Warner, would you like to add anything to this?
Yeah, I really enjoyed that March 25th hearing because I do think those examples that were given by the judges were really illustrative of how judges do all look at the Black letter law, but bring their life experiences to the bench as well. In particular, myself, I've clerked in the Division I Court of Appeals in Washington State, and I will tell you in that setting, working with other clerks and other law students to look at the facts of the case and help the judge apply them to the law. Those conversations amongst colleagues were incredible in my learning experience to understanding the importance of diversity and viewing directly how diversity does actually influence judicial outcomes. And in that way, it brought me much closer to wanting to learn more about the bench and bring other students of color like myself behind the curtain of the bench where we often don't immediately get access. And I think that's was an important lesson for me young in my career and one that we try to replicate for others here in the Western District.
Thank you, Mr. Warner. At the start of this year, President Biden's White House counsel wrote a letter to senators explaining the administration's focus on nominating judges who, quote, reflect the best of America and who look like America, end quote, including, quote, individuals whose legal experiences have been historically underrepresented on the federal bench, including those who are public defenders, civil rights and legal aid attorneys, and those who represent Americans in every walk of life, end quote. What impact has that letter had on promoting judicial diversity? And I'd like for Admiral Cruz and Ms. Diaz-Yeager to also respond. And if you could do so very quickly.
Yes. In my opening comments, I did mention that at our committee's first hearing, we read and references White House counsel Remus's letter at that time and spoke directly to the senators about it. The intent of doing that at the opening meeting was to really coalesce our committee members around the task that we had at hand, and that was very clearly to look for diverse legal experience, public defenders, civil rights attorneys, and youth legal aid attorneys ended up being in our group of applicants, and that was a part of our recruiting efforts. And then ultimately, as you see in our nominees, we have those diverse legal experiences represented, and hopefully we will see them on the bench here soon.
Yes, Mr. Chairman, if I will quickly respond. We at NAPABA see diversity as a term and a concept, really broadly defined, not just race and ethnicity, but also gender, sexual orientation, veteran status, disability, and as Mr. Warner just mentioned, professional diversity, law school diversity, public defenders, legal aid attorneys, government, non-government attorneys as well. So.
Thank you, Mr. Chairman. So I would echo what Mr. Warner, Mr. Cruz said, but more importantly, these nominations show the community that the widening of the net is occurring, and that means that individuals can come forward that are definitely qualified to be on the bench, but they're actually being invited and welcomed to the table for consideration.
Thank you. I've exceeded my time. Next, we will have questions from the gentleman from Ohio, Mr. Shabbat. Mr. Shabbat.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I'm a lawyer by training and spent nearly 2 decades practicing law back here in my congressional district in greater Cincinnati area. And since getting elected to Congress, I've served on this committee now for 25 years. I've served as the chairman for 6 years of the Constitution Subcommittee, and my ranking member was none other than the current chair, Mr. Nadler, for 6 years. And in my career, I've come across a lot of judges in courtrooms, as well as in judicial hearings that we've had over those decades. And I found that the vast majority of the judges that I've come into contact with well qualified and able to fairly adjudicate cases based on the Constitution, based on the laws that we pass in Congress at the federal level, and based upon the laws that the various state legislatures pass at the state level. Today's hearing is the second part in a series of hearings which seem to suggest that for many of my Democratic colleagues, that the most important determining factors in judicial selection ought to be race or gender or both. While it's important to have a diverse federal judiciary, I would argue that the most important factor is selecting and confirming nominees, whether it's a candidate or whatever, that they're qualified, highly qualified, and that they're impartial in their legal decisions. During his administration, President Trump nominated dozens of qualified and diverse judicial candidates who were time and again opposed by virtually every Senate Democrat, and likely some here on our committee, even though we don't actually get a vote, not because they were unqualified, but that their legal ideology did not align with the Democrats' political views. Take, for example, Justice Amy Coney Barrett. She was rated well qualified by the American Bar Association, and despite her academic and professional achievements, received 0 votes from Democrats during her confirmation process. Or take Judge Naomi Rao. She also received a well-qualified rating from the ABA, and despite receiving similar academic and professional accolades as Justice Barrett, she also didn't receive a single vote from Senate Democrats. Today, she is the first Asian Pacific American woman to sit on the DC Circuit Court of Appeals. And in March, we saw 2 of our Senate colleagues, Senators Hirono and Duckworth, saying that they would oppose all non-minority or non-LGBTQ appointees that Biden would appoint, and it goes on and on. So many of my Democratic colleagues seem to want to make everything about race, unfortunately. And they get to control everything, what these hearings are. They get to decide what we talk about, et cetera. I'd like to see maybe a hearing on the lack of conservative political or conservative professors at the college level, perhaps, or on city councils across the city. Very few conservatives there, or among the media, for example, reporters nowadays. But let me ask a couple questions here. Ms. Berseras, there are many examples like Justice Amy Coney Barrett and Naomi Rao and others whom the Democrats have time and again opposed, not because they're not qualified, but because they don't share the same political views. Could you comment on that, Ms. Berseras?
Sure, and in fact, sometimes I think that conservative minorities are the most discriminated group of nominees because, in fact, it is precisely because of their minority status, their intersectional status, if you will, being both conservative and minority, that the left deems them so dangerous. We saw this for a fact when Senator Durbin's memo was leaked back in the early 2000s, indicating that Miguel Estrada, that the Democrats viewed Miguel Estrada as dangerous precisely because, quote, he is Latino, unquote. And so I think that when we talk about diversity, representation is important. It is important on the federal bench so that the American public has confidence that everybody has access and that judges are impartial and that we all have access to justice. But when we talk about diversity, we have to include all members of racial and ethnic groups, not just the ones who expound a particular dogma. You mentioned Judge Naomi Rao, another good example. We see it time and time again that judges who are originalists or nominees who are originalists who want to apply the law neutrally without an agenda, they are not accepted by the Democrats, even though they represent diverse communities and are oftentimes, as you noted, the first member of that community to serve on a particular court.
Thank you very much. My time's expired, Mr. Chairman.
Thank you. We will now turn to the chairman of the full committee, Mr. Nadler, who I do not see on the screen. And with that, we will now go to the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thanks, Mr. Chairman. Thanks, Mr. Chairman. Thanks for calling this important hearing. Judges on the bench, it's clear, should look like our communities. They should reflect our communities. They shouldn't all, as we've heard today, they shouldn't all be from 1 or 2 law schools, shouldn't all be predominantly white males or former prosecutors or from big law firms. Diversity in the federal judicial bench helps restore legitimacy to the federal courts that hears and resolves issues that impact everyday Americans. So in December of 2020, the incoming Biden administration expressed an intent to nominate people to the federal bench who reflect the best of America and look like America, and expressed a desire to appoint people to open federal district court judicial seats that have been historically underrepresented on the federal bench, including public defenders, civil rights and legal aid attorneys, and those who represent Americans in every walk of life. And to assist in outreach and evaluating nominees for the federal bench, my state of Florida has created 3 federal judicial nominating commissions, one for the north, central, and southern part of the state, that are composed of appointees with diverse legal, educational, ethnic, religious, and racial backgrounds. The commissions reflect the diversity of population that makes our state of Florida so unique. And I'd like to ask Mr. Warner about this issue specifically and procedures, processes that can put in place to help ensure a diverse pool of nominations, and whether your committee addressed effective outreach to find qualified people for judicial vacancies. If you could speak to that, and then I have a follow-up for you.
Thank you, Representative. Yeah, this year we actually changed the composition of the committee from 6 members to 10. And I think that expansion gave us additional opportunities to find more professional diversity and put that professional diversity onto the committee. And I'll also say that the discussion after the recruitment process was made much more rich by that diversity of legal experience. We had folks on our committee with tribal law expertise, which we had lacked previously. And when vetting potential candidates to be judicial judges on a federal bench, it is helpful to have folks in the room that do have that native law expertise to be those evaluators. The diversity of the committee also created efficiencies in recruiting. When you want to reach out to minority bar associations and you look around your committee and you have several former presidents and current members on important committees within these affinity and minority bar associations, you've created incredible efficiencies because you can know that your judicial vacancy announcement isn't just going to be placed in the agenda. We'll have someone show up to the committee that can speak directly to the committee and talk to its membership about the importance that they have their qualified members apply. So I'll wrap up by saying I do think we created some real efficiencies and improved our committees this year by expanding the membership.
Thanks. In the first hearing that the subcommittee held on the importance of diversity in the judicial system, we discussed about having the need to have a diverse judiciary and how critical that is to maintaining public trust. The public trust in the judiciary would also seem to extend to how nominees with diverse backgrounds are treated during the confirmation process. The ranking member on the Senate Judiciary Committee has recently expressed the need to specifically scrutinize public defenders who are being nominated to the federal bench based on the perception that they could rule in a certain way. So, Mr. Ward, let me just finish with you. How does extra scrutiny or the call for extra scrutiny of nominees, particularly nominees who are not the traditional type of nominees to the federal bench, what does that do to impact the public's perception of the bench?
Well, Representative, I think you hit the nail on the head when you used the word traditional just now. I think as we see more civil rights litigators, more civil legal aid attorneys go through this process, you get that confidence and representation that you've seen someone before you get through the process. We can't promise that you're going to make it all the way through, but the idea that you have seen someone like you with your legal background go through it, and some will achieve, that confidence really does then engender more applications from people who may choose that legal route. And that's the same is true for law students. There are law students out there that may begin their careers at public defenders and now immediately think they can no longer be a federal judge. As we progress in this task, I'm hopeful that perception decreases and we get more of those applicants.
As am I, Mr. Warner. Chairman Johnson, thank you again for holding this hearing today. I yield back.
Thank you. We will next proceed to the gentleman from Ohio, Mr. Jordan, the ranking member of the full committee, for 5 minutes. Mr. Jordan, and your haircut makes you look a lot younger today too.
Yeah, thank you, Mr. Chairman. I don't know about that. I'm feeling pretty old here, but Mr. Chairman, thank you for this hearing. I'm going to yield to the gentleman from California, Mr. Issa.
Thank you, Ranking Member Jordan. And thank you, Chairman, for holding this hearing. I think one of the things that's coming out of this is the very testimony, I think, helps us frame questions I might otherwise not have asked. I want to first ask Admiral Cruz, you mentioned that likability was one of the characteristics that you thought should not be used. Is that correct?
Well, it is often in many contexts, like in law firms, likability does come up. I'm not saying it can't be used, but it certainly.
Would it surprise you that at the University of California and other universities in California, likability has been deliberately put in order to expand the diversity of the candidates? In other words, to move them up where they otherwise would not be qualified based on their test scores and grades. isn't likability, in your own words and observation, a great way to end up not necessarily getting the best candidate unless likability is somehow essential. I certainly would say if I wanted a salesman, I probably would like likability. I don't know that Admiral Halsey was famous for being particularly likable in my reading.
Yeah, I was Ranking Member Issa, I was talking about or referring to a particular context, just as you just did. Certainly in the context of of law firm hierarchy and fitting in, the more senior partners can often gravitate to people who are more like them, who are and that was the context in which
and I appreciate it. I just want to make sure we touched on that. Ms. Berseras, I want to go back to something you said. You gave us some startling statistics, basically looking at members of the bar of the three major identified minorities, that African American, Hispanic, and the like. You said basically they're each at about 5%. Well, their population would be larger than that, certainly 13 and 9% for African American and Hispanic. Would you say that if we were to use the lower figure, we would by definition have to reach to candidates to the detriment of candidates that might be more qualified based on an analytical statement?
Well, the number one qualification for being a federal judge is that you've attended law school. So if you haven't attended law school, you're not going to be picked. And the problem is that, as Justice Marquez noted in her testimony, we need to do a better job of making law school accessible to diverse communities. Now, particularly when you're talking about immigrant communities or working class or communities from lower socioeconomic brackets, cost comes into play. But you also have related to that the fact that the salary of a federal judge is in no way reflective of what people can make in law firms or in other aspects of the legal profession, even in some public interest areas of the legal profession. And so what we've found actually in Massachusetts is that it's very hard to recruit candidates from diverse backgrounds who are concerned about finances because they don't want to leave lucrative professions to take a pay cut to join the federal bench. So even some diverse candidates that may be qualified along every axis, judicial philosophy, professional background, all of the above, may not be willing to leave their current professions to take a job on the court. So it's not just that we have to increase the pipeline to law school, it's that we have to make to those who weren't born wealthy.
Well, I will take some pride in the fact that some years ago we delinked Congress's $174,000 salary so that judges have continued to rise while members of Congress have held their own salary in check. One closing question: does anyone dispute here that at the district court level, at the end of the day, you have exactly one judge judging your case, and as a result, there is no diversity at the table when you're before that one federal judge who runs his or her courtroom as he or she sees fit?
Yes, that's correct. I mean, as Judge Myers so aptly pointed out, judges wear black robes and they wear them for a reason. They wear them to indicate that regardless of their race, sex, sexual orientation, class, whatever law school they attended, whatever state they live in, when they put on that robe, they're a judge. And diversity of opinion doesn't matter. What matters is good judgment and impartiality and application of the law. And that's what the black robe represents. And so when a litigant comes before a judge, whether that judge is male, female, black, white, the litigant should be confident that they are going to be treated fairly and that they are going to get the same result based on the law. It should not be that a litigant is nervous to find out, oh, they drew Judge so-and-so, because that judge has a particular agenda, left, right, or otherwise. The judge only has one agenda, and that is the law.
Thank you. I yield back.
Thank you. We will now turn to the gentleman from New York, Mr. Jeffries, for 5 minutes.
Thank you so much, Chairman Johnson, for continuing to convene hearings on this incredibly important subject. Ms. Diaz-Yeager, am I correct that approximately 30% of the federal judiciary constitutes judges who were nominated by former President Trump?
I don't have those exact numbers in front of me, but as the HNBA is nonpartisan, we applaud any diverse individuals that are promoted by any party. We endorse individuals based on their qualifications and not based on their party affiliation.
Right. I didn't ask about party, but specifically just asking about the nominee in terms of who placed that nomination into motion. In terms of his judicial appointments, and let me know if you don't know this statistic, but approximately 90% of, I believe, former President Trump's nominations were white. Is that correct?
I believe that that percentage is actually accurate.
And am I correct that approximately 75% of former President Trump's nominations to the federal bench were male?
I believe that is an accurate representation as well.
And it's my understanding that he nominated approximately 54 circuit court judges who were confirmed, and that not a single one of the judges appointed during his presidency to the circuit court were African American. Is that right?
That is correct percentage.
And am I correct that of the 54 circuit court judges appointed by or nominated by President Trump and ultimately confirmed, only one was a Hispanic American? Is that right?
I don't have that percentage in front of me. I believe that is in fact accurate.
Okay. So I just think that obviously qualifications are paramount in terms of one's capacity to be able to evaluate the cases that come before an Article III federal court. I was proud myself to have an opportunity to clerk for a federal district court judge in the Southern District of New York, as was the case, I believe, with many of my colleagues. But it does seem that in addition to professional qualifications, which certainly should extend beyond the law school that one went to and or the professional experiences that one had beyond the so-called white shoe law firm or a federal prosecutor's office, that this is a country that was founded, anchored in part in the principle of e pluribus unum, out of many, one. And so the federal bench should seemingly reflect the many. The framers of the Constitution thought was important to the country in the broadest possible way: race, religion, gender, sexual orientation, region, yes, ideology, and also life experiences. So, Mr. Warner, you testified that people spending a majority of their career in private practice or as federal prosecutors comprise approximately 70% of active federal appeals court judges. Is that right?
That's right, Representative Jeffries.
And how does this lack of professional diversity impact the court and the justice that the American people can expect to receive?
Well, I think the skill sets on any bench that we look at should be considered as we make additional appointments. As we look at any given bench, if the bench is entirely full of former U.S. assistant attorneys and we have no immigration law experts, no defenders, no federal defenders, and no others with divergent legal expertise, I think it's fair for the public to worry that we may be missing other areas of broad legal expertise that we need on our federal benches. And so I think it is within these committees' purview to really focus on recruiting those types of legal expertise that might be missing on their particular bench to continue to engender trust in the community.
Yeah, thank you. I mean, I think a Congress that is diverse, broadly speaking, is consistent with what we're supposed to be as the House closest to the American people. You want to reflect that diversity in every possible way. It seems to me that the Article 3 federal bench should reflect that broadest possible diversity as well. Thank you, Chairman Johnson, for convening this hearing, and thank you to all the witnesses and the judges who serve this country well.
Thank you, sir. And next we will former judge, Judge Gomek. 5 minutes, sir.
Thank you very much, Mr. Chairman. I appreciate that. And I see that we still have Judge Myers. Is he open to being questioned?
Well, our first panelists are not questioned today.
Okay. Well, Judge Myers, thanks for your availability. Mr. Berseras, we heard earlier about what it means to walk into a court and identify by race with the judge, the people involved in the court. My experience in federal court was a great deal different. It depended on the client, and we were much more concerned with the political leanings and the beliefs of the judge as to how the client was going to be treated. If you were going into court, would you be more concerned that you were going before a very activist judge who is known for legislating from the bench, who didn't care for your political positions, or someone that actually, regardless of race, creed, color, gender, any of those things, actually was open-minded that you could see from prior rulings? What would your thought be as you go into that courtroom? Yeah.
Ms. Berseras, you may unmute.
Yep, got it. Sorry.
Okay.
Thank you for your question. My hope would be that whatever judge I was before, regardless of who appointed that judge, regardless of that judge's political views, and regardless of that judge's personal background, I would give my client a fair hearing. That's the way the system's supposed to work. And theoretically, there should never be an issue. But my concern in this day and age would be more that that the judge was politically motivated or had a political bias. The truth is, it doesn't really matter whether there's political balance on our courts if judges are doing what they're supposed to do, which is leaving that political and personal bias at the door when they put on their robes and coming to the bench as neutral arbiters of the law. So balance isn't really the issue when it comes to politics. The issue is judicial philosophy, and only when we appoint judges who understand that their role is not to solve social problems, but to resolve disputes pursuant to the law, only then can we be sure that our clients are getting a fair hearing.
Yeah, well, and having heard Judge Clarence Thomas, Justice Thomas brought up earlier, I couldn't agree with you more. And I remember Miguel Estrada, I mean, they left that incredible luminary out there just hanging, left his life in limbo month after month after month. And his treatment was so outrageous. But I'm sure you recall Clarence Thomas' statement that he was the wrong Black man. His race really made him more susceptible to being attacked. But I was glad to hear earlier the comment that we have too many judges from Yale and Harvard. There are outstanding law schools all over this country. some more so in certain fields than others. But I've been shocked at just how few Supreme Court justices are considered that went to some other law school, no matter how brilliant. I would love to see more diversity in that area. Would you comment about that?
Sure. Well, as a graduate of Harvard Law School, I can't say I think there are too many of us out there, but I agree with your basic premise that elite educational pedigree is not necessarily the best determinant of what would make a good judge. I was thrilled to see Justice Barrett bring that type of diversity to the court. Notre Dame is, of course, still a very prestigious law school, but it's not up with the ranks of Harvard and Yale in terms of the number of judges that we have from those schools. So I was pleased to see her bring that diversity, and I think she's a perfect example of how really you can find competent, brilliant judges from any law school in the country. So the test shouldn't necessarily be, did you go to Harvard or Yale? The test should be, are you impartial? Do you have the integrity? Do you have the professional experience after graduating from law school? And frankly, do you have a sound judicial philosophy that will tether your rulings to the text of the Constitution and the text of the statutes passed by Congress?
Thank you. And my time's expired. Thank you, Mr. Chairman. Thank you to the witnesses.
Thank you, sir. We will now hear from the distinguished gentleman from Arizona, Mr. Stanton, for 5 minutes.
All right. Thank you very much, Chairman Johnson. What an outstanding hearing thus far. Very educational, informative, and will affect our public policy moving forward. Thank you to the witnesses for being here today. In my home state of Arizona, we are lucky. We have 22 federally recognized Native American tribes. And we are so proud that the first Native American woman ever appointed to the federal judiciary, Judge Diane Humitiwa, serves on the federal district court here in Arizona. That leads me to my first question. I'm going to direct it to Mr. Warner. President Biden recently named Lauren King for a seat on the U.S. District Court for the Western District of Washington. If confirmed, Ms. King will become the third Native American currently sitting on the federal bench. In fact, Ms. King will become only the fifth Native American ever to serve as a federal judge. I'm really interested in that commission that you discussed earlier. I wanted to find out, as your commission worked to recommend candidates for judgeships, how did you account for such a historic lack of representation from the Native American community, and how did you focus on remedying that issue?
Thank you, Representative Stanton. I'll note that Washington has 29 federally recognized tribes and still no Native American federal judge just yet. And so how did the committee approach that work? Well, we first focused on, again, the professional experience that was needed and lacking directly in our bench to have someone with real Native law expertise. I will also say that there were only a few folks in the pool of applicants with that expertise. And that also spoke to us in terms of our committee needing to do a better job going forward in reaching out to Native law experts to be clear with them that our bench needs them, that the White House is interested in their application, and that they have an opportunity, should they apply, to actually move through the process. And so that is what we set out to do. We looked in our applicant pool for folks with deep experience in Native law. And of course, Lauren King rose quickly to the top because of her professional background and experience, which also lends to us possibly having the first Native American Article III judge in Washington.
That's great. My home state of Arizona is part of the 9th Circuit. Currently, there is only one openly gay member of the bench in the 9th Circuit. So I want to hear from Admiral Cruz and Ms. Diaz-Yeager on this one. Lack of diversity in the federal judiciary hurts our justice system. How do we go about making a plan to address such vast disparities in making up our federal bench?
I'm happy to address that first, Congressman. So how do we do that? What we do is we expand our networks, and you rely on affinity bar organizations such as the HNBA. So by expanding that network, you also expand inherently the pipeline. That pipeline then will help as we move forward, grow the number of diverse candidates that are, considered and go to the committee, make it possibly through the committee for selection. So I think that you've got to work on a level starting from law school, letting them know that this is a possibility, work on their pipeline, make sure that the committee members work with affinity bar organizations. Almost all of the affinity bar organizations have vigorous vetting requirements, and we have boots on the ground. So we know the individuals in that state, we know the qualifications, and we're more than happy to assist in providing qualified candidates move forward.
Admiral Cruz?
Yeah, Congressman, I would add that in order to fill the pipeline that Ms. Diaz-Yeager referred to, all those involved, all concerned, involved in the identification, the attraction, the vetting of judicial candidates really need to optimize their processes and intake, perhaps quite drastically. And I'm glad that Mr. Warner has highlighted a model, I think, that has worked in his venue. Bottom line, those involved need to go wider, go deeper. They need to beat the bushes. We at NAPABA are very active, capitalizing on our 90 affiliates and we're very active in certainly those areas where there's vacancies. And we are making sure that that we address the issues of oblivion around career possibilities, the lack of mentors that I mentioned earlier, role models, and frankly, the lack of leadership development.
All right, my final question is, what can we as members of Congress do to support your efforts to identify and encourage diverse legal professionals from our districts and communities to join the judge candidate pool? And that's either for Mr. Warner, Admiral Cruz, or Ms. Diaz-Yeager.
Representative Sand, I'll start by saying I think appointing diverse commissions is really the key to some of the success that we've had in the Western District of Washington. And in my last answer about Lauren King, I should have mentioned that one of the reasons we had the ability to evaluate tribal law expertise is because we had a tribal law expert, Ryan Ramirez, who represents one of our local tribes, on the committee. And so we had that level of expertise to truly say this person or that person will have an ability to bring value to the bench from a professional and diversity standpoint that we need.
And if we had to add one more thing to a wish list, I mean, if we could, if you could influence folks in the other chamber, the senators, to broaden out their identification and search process for candidates, utilizing the resources such as the HMBA, such as NAPABA, such as the MBA, and all the other affinity bars, I think it would inure to the benefit of the entire process.
And I would add to that, that if the members of Congress actually expand their networks, expand the individuals that they hire to work in their offices for those experiences, then you are leading by example. And by leading by example, you can then encourage people within your networks to also do the same, and that would also help increase the pipeline and the networks and the mentoring.
Thank you much. I yield back.
Thank you. We will now turn to the gentleman from Louisiana, Mr. Johnson, a distinguished lawyer, for 5 minutes.
Thank you, Mr. Chairman. I appreciate that. This is an important hearing, and this subcommittee is, as you noted earlier, is having its second hearing about the importance of a diverse federal judiciary. As Ms. Berseras said so well a few moments ago, the black robe of all judges holds important symbolism. I mean, regardless of a judge's immutable characteristics or philosophy, we all believe in our system counts upon them to be fair and impartial and objective. And the other symbol of our profession is Lady Justice, of course, and that's the symbol. She wears a blindfold to show the importance of the application of the law without corruption or favor or greed or prejudice at all. So hopefully all of us would aspire to appoint judges to the bench that it doesn't really matter what their background is, as long as they're fair and impartial in the application of the law. That's the idea. But as we all know, sadly, a lot of that is being jeopardized by politics today. And that's the unfortunate situation we find ourselves in, is that more and more of the American people are losing faith in the institution of our system of justice. And that's of great concern, I know, to all of us. I was a federal court litigator for 2 decades prior to my election to Congress. And some of my former colleagues at the bar believe, as do many Americans, that leading Democrats on Capitol Hill, for example, not all, but some, have used the cause of diversity to politicize the judicial selection and confirmation process. I want to echo what's been touched upon previously here today, that some Democrats have repeatedly opposed women and minority nominees to the bench just because they were chosen by Republican presidents. And it's a vicious and personal opposition sometimes. We mentioned today Justice Clarence Thomas. Ever since his nomination to the Supreme Court, he's been unfairly targeted and maligned in so many ways. Senate Democrats later filibustered President George W. Bush's nomination of Miguel Estrada to the DC Circuit Court. We've talked about that. Ms. Berseras mentioned today that the leaked memo by Senator Durbin, who stated that Mr. Estrada was, quote, especially dangerous because he's Latino, unquote. More recently, Democrats opposed President Trump's diverse judicial nominees. I mean, Supreme Court Justice Amy Coney Barrett, only the 5th woman to serve on the nation's highest court, received exactly 0 Democrat votes, as was mentioned today, during her confirmation, even though she was rated well qualified by the ABA and has impeccable character and credentials. And during her earlier confirmation of the 7th Circuit, we all remember Senate Judiciary Committee ranking member Dianne Feinstein outrageously maligned her Catholic faith by pronouncing to Justice Barrett that the dogma lives loudly within you. So much for the ban on religious tests. I just have a couple moments. I want to ask Ms. Berseras, what do you make about the Democrats' consistent opposition to diverse nominees selected by Republican presidents? You've elaborated a little bit on that this morning, but I wonder if there was anything more you wanted to add on that.
Well, we can't both say that we want to increase the diversity of the federal bench and then reject nominees who would do that. If diversity truly is a paramount concern, then we need to accept it in all its forms.
Can you think of any other recent examples where some Democrats, let's say in the US Senate, resisted and unfairly maligned a diverse judicial nominee that President Trump nominated?
Sure. Well, we talked about Judge Naomi Rao a few moments ago. She's one of the first ones that come to mind, particularly because, like Miguel Estrada, her qualifications were so impeccable. And she would have did bring diversity to the court on which she was appointed to. It was a historic nomination. And, it's sad to me to see that people who purport to want to diversify the federal bench only want to do so when those diverse nominees come from their party. It'd be nice to see them support them across the aisle. Let me take a moment to say that I know that the Hispanic National Bar Association has been particularly good. I'm not quite so sure about recent years, but I know that overall their track record of supporting nominees across the aisle has been pretty good. And I'm proud of that, but that's not necessarily true for the politicians who are voting on these nominees.
I've only got 20 seconds left. I'll just say, I'm going to state the obvious that I think all members of this committee should aspire to getting us back to the point where we nominate people on their merit and not necessarily on all these other things and their politics and everything else. I don't know how we put that genie back in the bottle, but I hope one day we can, so that we can restore the American people's faith in our institutions. I'm out of time and I yield back. Thank you, Mr. Chairman.
Gentleman yields back. We will now hear from the extremely distinguished gentlewoman from North Carolina, Representative Ross, for 5 minutes.
Thank you very much, Mr. Chairman, and it's North Carolina Day in this committee. Welcome, Judge Myers. It's great to see you. And of course, we've got somebody from Duke who I will be asking a question of in a few minutes. So I've practiced in North Carolina. Representative Bishop and I talk about this quite a lot. We graduated in the same law school class. And so you've got a Democrat and a Republican from North Carolina sitting on this Judiciary Committee. And I will say President Biden just signed into law a bill that we got through this committee. So bipartisan work can be done. But I've seen how partisan these kinds of appointments can be. And of course, Judge Myers knows about how long it took to fill his particular position because of the differences between an administration and our senators. And before Judge Myers was appointed, there were two African-American women who were rated as very well qualified, who simply were rejected by our senators, one of whom had been elected statewide twice. So we need to get past this partisanship and focus on qualifications while we focus on diversifying the bench. I have practiced in the corporate arena, and I have practiced before administrative agencies, and I've been a civil rights attorney. And I can tell you that the more diverse the perspectives and the backgrounds that we bring to any collective body that's making a decision, the better decisions we're going to get, because we cannot simply just have an echo chamber of people who see things one way. Our judiciary, as our legislature and our Congress, need to reflect the people they serve and need to have the lived experiences of the people that they serve. And so I appreciate all of these comments that we're getting here. I'll share one anecdote before I ask my questions. I was the youngest woman in the North Carolina legislature when I first got elected. And the speaker asked me about appointing people to some of these committees. And I gave him a number of names of highly qualified people. And he said, "Where have these people been?" And I said to him, "Mr. Speaker, where have you been?" And that leads to this next question for Mr. Warner. So in North Carolina, when we've gone about appointing judges, occasionally there will be these ad hoc commissions where we'll try to get different people, people's input, but there isn't a more formal process like you have. Could you tell us how we can replicate this around the country and get more input from a variety of people so that it's not just left up to political whim?
Thank you for the question, Representative Ross. I'll start by saying that the co-chairs of the current committee would love to help and answer your questions, but I'm also sure that Senators Murray and Cantwell's offices would also be happy to work with all of you to replicate the processes that we've continued to iterate on in the Western District of Washington. And I will say that it is really a conversation with the senators' offices to understand the needs of the senators' offices along with the White House every time that we have a vacancy. And then we get together and look at our last committee to decide whether we need to add additional members to really reach out into our community to make sure that we are finding those people that were already there, and we just need to look a little bit harder. So happy to work with you or your staff or make those connections.
Thank you very much. And Ms. Diaz-Yerger, given that many judges look to clerks in order to, well, we look to see if they've had clerkships. How do we diversify those clerkships? How do we get more people in that pipeline?
Well, there's several methods to get more people into that pipeline. The first method is to encourage those judges to look outside their own networks and to look at different schools and to consider different individuals based on their experience, not just based on which school they went to. The other way is to actually work at the law school level and let those individuals know that these opportunities do exist for you and how to set your trajectory to actually be able to be considered for a clerkship. Many of them, because they don't have the network, they don't know the connections, they don't have family members that are lawyers or judges, they don't understand the process, they don't know that it's actually something that can happen to them. And if you ask when you're in law school and you ask somebody about the clerkship, their usually response is going to be something along the lines of, it's who you know. And so we need to broaden that scope more. So it's kind of a, dual prong approach. You're looking at the law schools, making sure they understand this is how you do it, it's available to you, and then asking the judges to, broaden their scope, broaden their network as to who they would consider.
Thank you very much, and I yield back, Mr. Chair. My time's expired.
Thank you. We will now proceed to the distinguished businessman from Wisconsin, Mr. Tiffany. Just as Mr. Issa is a distinguished businessman. Mr. Tiffany.
Mr. Chairman, you're pouring it on this morning. Thank you very much. First of all, I just want to say in regards to Judge Myers, thank you so much for being here today. And I would like to know who the 21 people that voted against you, because if we're seeking a diverse judiciary, they clearly cast the wrong vote. Admiral Cruz, over the last 30 years, have we made progress?
In judiciary?
Yes.
Yes, obviously, I think we have. I don't have the statistics in front of me, but certainly.
No, I appreciate that, Admiral Cruz. Thank you, because I think we have too. You especially focused on AAPI judges, and Senator Whitehouse, a Democrat from Rhode Island, called her a cartoon of a fake judge. Do you think that's an accurate statement? Do you think it's an appropriate statement?
It's not a statement I would use.
Yeah, thank you very much, Admiral. I appreciate that. I would also point out that Ivy League schools are currently discriminating against Asian American students, just for the record. Ms. Diaz-Yeager, in regards to Miguel Estrada, I want to make sure I say this correctly. Democrat leadership, back when he was being considered in the early 2000s, they said he's especially dangerous because he is Latino. I find that statement reprehensible. Do you?
I'm not familiar with the statements that were made. I don't believe that statements that deal with personal traits are ever appropriate.
Yeah, thank you very much. Democrat leadership made that statement, and I would encourage you to take a look at that quote that was found. It is, I believe it's awful. Ms. Berseras, have we made progress?
100% we have. And in fact, as the numbers that I submitted in my testimony suggest, minority groups are overrepresented in the judiciary compared to their population in the bar. So we've done a great job at recruiting people to the bench and getting minority candidates on the bench. It is an important thing to do. We need to continue to do it. But the most important thing we need to do is to increase the pipeline and the pathway to law school.
But you think we're headed in the right direction and we are making progress as we speak. Is that correct?
We have made progress and we continue to make progress.
Yeah, that sounds great. You know, I really think, Mr. Chairman, I get two things from this hearing. The concern, so we hear the concern about diversity, but two things are coming out of this. We're making real progress. I mean, I listened to the gentleman from Washington who was very eloquently stated how they are making real problems. They're fixing what he believes is a problem out there in terms of recruitment. And what we're hearing today is that real progress is being made. And it was as a result of a Democrat United States senator who did not have it right, that he's been able to convince her that she needs to take a different approach to getting diversity to the bench. So I just think that there is real progress being made in that way. I think the second thing that's come out of this is, as Judge Mcshane said, there's a problem with where they come from. And no offense, I hope, delivered, Ms. Berseras, but it sounds like we need to get outside of the Ivy League schools here as far as where we're getting recruits. So what I'm hearing is we're making real progress. But it does deeply concern me if this is an effort to do the same thing as this Democrat-run Congress did with the farmer and restaurant program, where we now have a federal government that is actively discriminating against certain members of society. This is going to end really badly, because I think about that shield that is in our room, in the Judiciary room, that says e pluribus unum. And Representative Jeffries referred to that earlier. Out of many, one. We're seeing active discrimination that's going on by this Congress of the United States, and that is not a good direction to be going in. So if diversity is a code for judicial activism, this is going to end badly for all Americans. And I mean, it's going to end badly for all Americans because I think all Americans, regardless of race, creed, or color, what they expect when they come into the courtroom is they want to have justice. And this is one of the fundamental pillars of a free society, that all men are going to be created equal before the law. Let's make sure that is happening through this process. I yield back and thank you very much for the compliment, Mr. Chairman.
Thank you. And I might add that we've tried hard to steer away from politics in this hearing. Diversity on the bench is certainly an attribute that is valuable. It's not to be disparaged. We can have different views about it. And certainly some who may tend towards originalism believe that white males interpreting the Constitution through the eyes of a white male who existed back in when the Constitution was written suffices for today's realities, but it's scary to people who go to court and all they see is white males on the bench. Mr. Warner, since you were referred to,
Mr. Johnson, if I may interrupt for just a second, I hope you'll allow Judge Myers to make a comment in regards to your statement. I yield back. I will be done now.
Yeah, well, I'm gonna yield to Mr. Warner, who was referred to for his response, if he should have one.
Thank you, Representative Johnson. Yes, I would like to be clear that Senator Murray needed no convincing in reconstituting our committee to broaden the diversity of the group. In fact, I was a bit hesitant to extend our group all the way to 10 members from an administrative perspective, because that was my role. I will tell you that I was wrong in that we really did create efficiencies with a larger 10-person committee, again, because that committee truly knew the community and the folks that were hiding in plain sight with the expertise that we needed had connections to the membership. And in that ways, we are even more efficient than we have been in the past. And I will also say that today, yes, I believe that we have made great progress, but it is still the case in the Western District of Washington that we have never had a Native American or Asian American judge, and that is not progress enough. And so we have much more work to do. Thank you.
Thank you. I'll now proceed to the distinguished gentle lady and former Lieutenant Governor of the state of Minnesota, and also a lawyer, Representative Fishback, for 5 minutes.
Well, thank you very much, Mr. Chair, and I appreciate the opportunity. I want to thank all of the testifiers for being with us today, because I really appreciate just the perspective and the information. But I do understand that one of my colleagues has a few more questions that he's like to follow up on, and I'd like to yield my time to the good Congressman Issa.
I thank the gentlelady. You know, there's no limit to the amount of good questions I think that come out of a hearing like this, and I thank you for yielding. You know, it's interesting. I've put about 8 members of my staff over 20 years through law school, and as I've watched them each go to law school and then take the bar, I've been struck by the fact that law school doesn't teach what you need to know to pass the bar. And neither of them seems to teach what you need to know to be a practicing attorney. So I'm going to ask, and I'll start with Ms. Berseras, but I think each of you could answer this. If we assume that, as one of my favorite but unheard of songwriters wrote, Gary Hall, who wrote, "Any little boy can be the president if he was born in the USA. Any little girl can too." The fact is, we know that to be president, you've got to be 35 and naturally born. Let me just quickly, if you're 25 years old and graduate from law school, what is it you do not have that you need to acquire in order to be a federal judge? And I'd like all of you to answer it in writing, but maybe we'll start with just one oral answer.
Well, I would say experience, maturity, and judgment. the most important quality of being a judge is good judgment. And that's something that it sometimes takes people, you know, several years of practice to acquire.
So, although we don't have a strict age, we generally take someone in their 40s or 50s to be federal judges. So they kind of get the age and some experience. And I'm going to follow up, since you're a Harvard alum. None of the attributes you mentioned actually have anything to do with the, if you will, the quality of the law school you went to or the prestige, correct?
That is absolutely correct.
And just to follow up, because I haven't practiced before the federal bar, when you're before a federal judge, you've got a pretty diverse group of cases. You've got patent, antitrust, a host of criminal cases, obviously immigration at times. Is there any one person, any one lawyer you ever found who came to the bench with the ability and experience in all those areas?
No, of course not. In fact, I'll refer to my own father, who's a judge on the Second Circuit Court of Appeals, Judge Jose Cabranes. He was appointed to the bench by President Carter at the age of 38, the first Puerto Rican appointed in the continental United States. Many people thought he didn't have the experience at the time. He had been a litigator for only a few years and then was coming to the bench from being general counsel of Yale University. People thought he didn't have enough courtroom experience. He had never tried a case to completion, although he had argued many motions. I would argue, and I hope most of you would agree, that he's turned out to be a fantastic judge, a judge that's respected on both sides of the aisle. And so you don't have to have experience in every area of the law to be a district court judge. Most of judging you will learn on the bench. You know, judges go to judge school once they're first appointed, and they learn from their colleagues, and they learn from experience. So what's really most important is not experience in terms of have you tried cases in every single area of the law that you might face. The question is, do you have maturity of judgment? Do you have a sound judicial philosophy? Do you have integrity? And do you have the legal skills to learn on the job and to make decisions quickly and decisively and impartially?
Now, I'm going to presume that if you've read Alan Dershowitz's book from about early in the 20th century, when there was a proposal to reduce the number of Jewish people attending Harvard, I would assume that you would object to us limiting the number of Harvard nominees in the future.
Well, I don't think there should be any arbitrary limits. Our Constitution anticipates that this is a political process. The Constitution left it to the president to make the appointments and the Senate to confirm, and the senators have a role to play in terms of selecting nominees to the district court and sometimes the Court of Appeals as well. That is all appropriate and consistent with our Constitution. I don't think there should be any arbitrary rules about who they should pick or what their backgrounds should be.
Well, thank you. And Mr. Chairman, at this time, I think it's appropriate to ask that the article from the Pew Research Foundation be placed in the record because it quite frankly shows that Jimmy Carter had more appointments than Donald Trump. And as was just noted, some of them are still on the bench.
And I think his were a little more diverse as well, President Carter. So noted and without objection, so ordered. Next, we will hear from the gentleman from Wisconsin, Mr. Fitzgerald, distinguished newspaper publisher, for 5 minutes.
Thank you, Mr. Chair. Appreciate it. I just wanted to kind of back up a little bit and if we could kind of address what some of the members had touched on. And that was kind of the profile, I think, that's being developed by specific courts in a predisposition on how they take cases, receive cases, who presents in front of them, which attorneys are either shopping venue or looking for a specific judge. And because my experience has been, if you want an attorney that practices in a specific court with specific attorneys, you go to one district or another. I mean, it's a predisposition that you would actually make the determination to which you're hoping for the best outcome. And then, let's talk about the circuits. When you're in front of a 3-judge panel and you kind of know that, well, we're in pretty good shape going into this case, as I've had many discussions with attorneys that have represented the state legislature over the years. I mean, isn't that as big an issue as anything that we've kind of discussed here this morning? And I was wondering if Ms. Berseras could address that first.
Yes, I agree. Forum shopping is a problem. It shouldn't be that way. Theoretically, you should get the same justice in the Eastern District of Texas that you would get in the Southern District of New York. That is absolutely what we should aspire to. I'm not sure how you fix that, but I agree with the premise of your question.
Mr. Warner, do you have a comment on that aspect of kind of what we've been discussing here today?
I'm here to focus on the Western District bench and our appointment process, but I will try to answer in saying that, forum shopping happens for many different reasons. I don't think it's necessarily tied to the diversity that we are talking about today, but one aspect that could be included there is, do benches across the federal bench in particular have the legal expertise that's necessary to address the broad issues before the court? So to the extent that diversity of legal expertise plays a role in forum shopping, then I guess, yes, I agree that diversity of legal experience is important.
Very good. And D.S. Yeager, Ms. D.S. Yeager, do you have a comment on that topic?
Well, I agree with what Mr. Warner said. I mean, forum shopping does in fact happen. It happens for a plethora of reasons, and perhaps a diversity of experience, diversity of knowledge with regard to the area of expertise may actually play into part of that.
Yeah, so Mr. Chair, I mean, my question and what I've been pondering as we've been listening to the input today is, how does this happen? I mean, where are these judges coming from? Why is there this predisposition, whether it's in the Western or Eastern District of one of the states, or if you end up in the 7th Circuit in Chicago, whatever it may be, that suddenly it's about the makeup of the judges and their views, which many attorneys are well aware of before they even enter the courthouse. So I think that's something to be pondered as much as any other question about race and equity that we've heard today. So, and I yield back. Thank you.
Thank you. We will now go to the, let's see, the gentleman from Oregon, Mr. Bentz. Mr. Bentz, you may proceed.
Thank you, Mr. Chair. And I'd like to begin by giving a shout out to Justice Mcshane, who graduated from Lewis Clark Law School as I did. And I am sure he's doing absolutely wonderfully in whatever the competition structure is between my law school and Harvard. But a shout out. I would like to ask him a question, but of course, we're not asking that panel questions. So let me ask this question of Ms. Berseras. It happened that I was asked by my predecessor to serve on the review panel for possible appointees to the 9th Circuit and to the Oregon District Court, not that long ago, 3 or 4 years. And when I was, there were 7 of us, and it was highly political. We had initially 21 applicants, I believe, and I said that's too few, so we reopened the application process. We ended up with 45, I believe, and we were looking for both recommendations to the 9th Circuit and to the U.S. District Court out of that pool. There then ensued a review of 44 big, huge piles of documents that reflected these people's absolutely wonderful backgrounds. I could not believe how qualified those people were. And then we reduced it down to 14, and then we interviewed those people for 2 days, 7 one day and 7 the next. Incredibly incredible people, every one of them. My question is this: before we went to those interviews, all we had was paper, and I didn't just feel inclined to Google anybody or anything else, and I don't recall any indication in the application forms of what race or what gender or what minority or anything of that nature. In other words, my review was without that input. And my question to you would be, was that the right way to do it? Or should we have been told, should there have been a form calling out the minority status of these applicants?
I actually think that's highly unusual. I've served on a search committee for a magistrate judge, and my husband actually serves on the Judicial Nominating Commission for our state. And I've had some informal experience also advising people in White House counsel's office about potential nominees. And it's always been, from my understanding, a transparent process in terms of people have an opportunity to identify their backgrounds. I've never seen a process actually, or heard of a process that didn't ask them to identify their backgrounds. That doesn't mean that's not an acceptable way to do it. But I do think the point you made initially about expanding your search is an important one, because you said that you started off with a certain number of candidates and you asked for more. I think a lot of, when we talk about increasing the diversity on the federal bench, recruitment is a big part of that, encouraging people to apply, reaching out to the affinity bars, as we've talked about, and getting the word out that these are opportunities that are available, that people should throw their hat in the ring. So I think the main way to get diversity, in addition to increasing the pathway to law school and the number of law school graduates who are people of color, would be in terms of recruiting and getting people to throw their hats in the ring. That's where we can make the biggest difference, I believe.
Thank you for that. And in the 1 minute I have left, I'll ask this question of Mr. Warner. And it seems almost as if, and I think a number of previous folks have bumped into this, that we are condemning, if you will, the current folks on the bench by saying that they are inadequate and that they are, as a group, not adequately representative of different portions of our population. And that appears to be, and this is not to say that I in any way support not having minorities. I'm totally supportive of having a balanced bench, as long as we don't give away, as Mr. Johnson mentioned, the primary focus on the merits. But my question to you is, how would you measure that inadequacy now? I know we heard about at the district court level, when a minority comes before a non-minority judge, there's a problem. What other problems come up, let's say at the appellate level, by virtue of this inadequate representation of minorities?
Thank you, Representative Bentz. First, I wouldn't say that we are at an inadequate place with our current Western District bench. In fact, we're very proud of the diversity on our Western District bench that's currently there. But the reality is that we have several judges retiring or going into senior status. And so we have 5 vacancies. And those 5 vacancies are coming up now in a context where, we have more diversity within our judicial community, within our legal community than we did 15 years ago. And the judiciary should continue to reflect the changing landscape of our local community. And so we were intentional about doing so in this process.
Thank you. Thank you, Mr. Chair. I yield back.
Thank you. And Representative Bentz, I neglected to point out the fact that you yourself have served admirably as an attorney, partner in a law firm for decades, and also a farmer. So thank you for your service. And I believe that we have exhausted the number of representatives who are available for questions. And so we are at the conclusion of today's hearing. So I want to thank all of the panelists for appearing and for their testimony. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, our hearing is adjourned. And by the way, I like the bolo tie, Representative Issa.
Well, thank you. You know, being in the West, it seemed appropriate to wear today. I'm in San Diego. So, you know, in the land of Ronald Reagan, an open shirt would be inappropriate, but not this tie. So thank you. Thank you again for holding this hearing. I think we all benefited. I would like to remind all the witnesses that I did ask for an in writing list of those characteristics they think are most important in the way of skill sets before coming to the bench, because I think that the diversity of their answers could well help both you and myself.
Thank you. And I want to thank especially thank the members of the first panel who had the staying power to stay throughout the second panel. So once again, thank you for all of the panelists, and everyone have a great day. This hearing is adjourned.